Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Here's your host, attorney Anthony Reeves.
Who's the vocational expert in the hearing? All right, there's probably a bunch of videos on YouTube that you can read about this, and I've had a few people ask me, and I said, you know what, I'll throw it out there for chance. So you go to your hearing. You either have an attorney or you don't have a representative, or you go by yourself, whatever the case may be. All of a sudden, the judge says there's a vocational expert in the room. Now, the judge is going to explain to you who that person is. But by the time you walked out, you're probably like, I'm still a little shaky on what that person is. A vocational expert, and this is what's supposed to happen in theory, a vocational expert is an independent contractor who has no interaction with the Social Security Administration, with a judge or you prior to the hearing, who's there to provide expert testimony about two things. First of all, they are there to give a description of the kind of work that you've done in the past, because one of the steps of the 5-step process in Social Security is, can you do your past work? So they're going to utilize, typically what they're going to do is they're going to basically say, in accordance with the dictionary occupational titles, and here's what I tell people, every job you do has a description and a code attached to it. Every job that's out there typically has one. So what happens is that with every job, depending on which classification system you use, whether it's Occupational Network or OccuInfo.net, or whether it's a Dictionary of Occupational Title, each one has a description. And under that description, there are various duties, responsibilities, what it is reasonably could be expected in terms of the educational level, the reasoning level. It's also going to have information in there about the skill level, whether it's unskilled, semi-skilled, or skilled. It's also going to have information about the educational level, typically, and it's going to have information about that particular job based on the exertion. Is it a sit-down job? Is it a light job? Medium? Heavy? Very heavy? So what this person is going to be there to do is going to sit there and listen to what you have to say about the work you've done, which is why I tell people, don't sugarcoat it. Because most people do what I call our what's known as composite jobs, meaning it's usually their job plus other things that are not totally related to theirs, meaning it's not the only thing they do. Like one of the examples that I've given to people in the past is that I said I was hired as a dishwasher. However, as an added perk to me, they offered me the ability to clean the bathrooms and the restaurant. This was a Chili's before the place opened. So I had a composite job because they hired me as a dishwasher. Cleaning bathrooms is not the normal part of your job description for someone who's washing dishes. However, I had a composite job. So a portion of my job was janitorial, a portion of my job was dishwasher. So that's the first thing they're going to do. Second thing they're going to do is they are going to answer questions posed to them by both the judge and your representative, or you if you're going by yourself, about how a person under a hypothetical set of facts may be able to work under different scenarios. Let me tell you why it's important for you to understand the hypotheticals. Because a lot of times people walk out those hearings saying, well, the vocational expert said I can do work. No, that's not what they said. What's happened is no one's going to sit there and ask the vocational expert, hey, like assuming I'm the claimant. And they're not going to go up to him and say, hey, Mr. Vocational Expert, you think Mr. Reeves can go back to work? Absolutely, man. He's a slacker. No, that's not how it goes down. What the judge is going to do is the judge is going to say, assume a hypothetical individual. So what they're saying is assume some random person that may or may not be you, but assume some random person. And we're going to have a certain set of parameters that are consistent with that person, meaning we want somebody who's the same age as the person who's sitting here, meaning you, same education as you, same work background as you. Now, remember I said they're going to look at the kind of work that you've done. They've also, I said two things, but it's actually three. The other thing is they're going to say, is there any skills you acquire from the jobs that you've done? So they're going to take that in consideration. Then what's going to happen is that somebody is going to ask, the judge is going to ask them a series of questions. They're going to say, assume an individual with all the things like the claimant, meaning you, but they can only sit this long, stand this long, they can't deal with these environmental factors, they can't deal with this. Is there any work available? And then they're going to give testimony in response to that. Now, if you have a representative, because a lot of times people don't realize when they hear that, they get offended. And usually some judges take it both extremes. They'll say, here's one extreme. Now, if you were to give credit to what the person was saying here today, can they work? Oh no, because person just testified that they're in the room all day and they can't go out, they can't deal with the people. No jobs. So you're sitting here and you walk out and you're confused because on the one hand, the expert was listening to everything you said and said that you couldn't work. But they didn't say you couldn't work. What they said was, if you take somebody like the one this hypothetical random person, and you said they could only do this, they can work. But if they can only do this, they can't work. So it gets important for your purposes to know this. The expert is not there to decide whether you're disabled. That's what the judge is there for. That person is only there to render expert testimony. Now, this is about the work that you've done in the past and about whether work is available under hypothetical circumstances. Because what's going to happen is when the judge goes back to his or her chambers, they're going to look at all the facts and they're going to look down and going to say, looking under this here, which one of these scenarios closely reflects you? Now, this is the one thing that I tell people all the time when I say sometimes it might be wise to get a representative. You can't just randomly attack the person because sometimes what happens is people are saying, there ain't no jobs out there. No, it's not the judge's responsibility to go out and find you a job and get you an application. We're just talking numbers, okay? So you've got to know how to properly ask that vocational expert questions that will give you responses that accurately reflects your situation. Now, some of you are going to say, how in the hell do I do that? This is where you need a representative because I can't really lay it out to you accordingly because there's a few things you're going to want to look at. You're going to want to look at what does the medical records say? Are there any particular limitations that the medical records has in there? How do you identify those? And this is where I tell people, you bear the burden of proving that you're disabled. You've got to be able to ask that expert specific questions regarding limitations. So for instance, you can't go to the expert and say, well, if somebody had to go to the bathroom all day, can they work? And the first thing the expert is going to say is, what does that mean? And you're getting frustrated because in your mind you're thinking that makes common sense. If I got to go to the bathroom all day because I've got a weak bladder or I've got Crohn's disease, which causes me to have to go and have bowel movements or runny bowels, stools all the time, they're not going to hire me. And so what are they talking about? No, it's not that. You got to be able to quantify it specifically. So asking the question, assume somebody goes to the bathroom all day, is not a good question because it doesn't tell the expert specifically what all day means. Now, typically breaks are 15 in the morning, 15 in the evening, 30 minutes for lunch. But here's a more specific hypothetical. Let's say you ask the expert, assuming an individual who, in addition to the normal breaks, would have to have a minimum of 10 minutes every 30 minutes all day because of unpredictability with regards to their bowels, and they find themselves having to do that. Now, I've had people like that where they'll say they have to go to the bathroom basically twice an hour, and because twice an hour because they're and it's pretty much they don't know they can be there a minimum of 10 minutes or even half an hour, but on average it's twice an hour. That is specific, and you say, well, some of them may say, well, if it's and listen carefully. Some employers might, but they may tell you that the average employer is probably not going to tolerate it. But that's not the key. The key is that you've now said something specific. You've told them 10 minutes every half an hour, and it's unpredictable when those 10 minutes would occur. So that means it could be when you first get there 10 minutes, or it could be after you've been there 5 or 10 minutes. But every hour you need 20 minutes off, and those 20 minutes can come unpredictably. So basically, just do the math with this. So you basically say 20 minutes, let's say an 8-hour day, 20 minutes 8-hour day, it's about 160 minutes, which is basically 2.5 hours, plus 2 hours and 40 minutes. So basically, in addition to the 15 and the 15 and the 30, which is an hour, they also need an additional 2 hours, 2.5 hours for bathroom breaks. So that means that's in a normal 8-hour workday, 3.5 hours of it. Well, you take, not even take that out of the equation. Out of an 8-hour workday, where you've got an hour and a half taken away from that 8 hours, well, it's usually 9, depending on how you want to look at it, because you basically, if you start your workday at 8 o'clock and you end at 5, you're only working 8 hours because you're taking an hour for lunch, and maybe they probably let you have the paid lunch, however it works out. But just think of it like this. If you're working from 8 to 5, about a 9-hour day, it takes off for lunch, they don't pay you for lunch and so forth, but just say 8 to 5. Guess what? If you have an hour for lunch, half an hour for lunch, and then 30 minutes here, think about it, 15, 15, 2 breaks. Let me slow it down. 15 minutes in the morning, 15 minutes in the afternoon. That's 30 minutes. 30 minutes for lunch. That's an hour. So that means out of a 9-hour day, you've got an hour taken away for breaks. You with me? But now you're telling the court, based on those limitations I've just provided to you, that in addition to the hour you get normally, you need an extra 2.5 hours per day. So that means out of an 8-hour workday, they're only getting about 5.5 hours worth of, make sure I got my math right. They're only getting about 5.5 hours worth of work out of you. They're going to tell you there's very few employers that are going to hire you under those circumstances. I know that sounds gippy when I say it all kind of like that, and I know some of you are scratching your head. Here's what I need you to understand. When you walk in that room, that vocational expert is there to provide some very specific testimony. And I know I'm a representative, so I'm going to say this all day. If you don't know how to properly ask questions that takes in consideration the evidence that you have in your file, and you ask those questions in a very finite way so that you get the type of answers that you need to support your case if you lose so that you can properly appeal it, you may be hurting yourself more than you realize. Just know this. Vocational expert is not there to determine that you're disabled. Is not there to make a decision about whether you are or you're not disabled. They're there to provide expert testimony. And you need to make sure you totally understand how to ask them the proper questions and get the necessary evidence and information from them so that it supports your case. One, to help you win and protect yourself on appeal if you